So a lot of individuals are waking up to the fact that they're being regulated and controlled by the government through the statutory laws, through statutory powers. And they're realizing that they're being classed as an artificial person before the law. For example, as being classed as a taxpayer before the law, to have to operate from the statutory capacity of being a taxpayer. All right, so I asked the artificial intelligence that very question, that question that's bothering and preoccupying some individuals' minds. Does being forced into statutory recognition under Canadian domestic law breach the International Covenant on Civil and Political Rights, Article 16? Article 16 of the International Covenant on Civil and Political Rights recognizes the right of everyone to recognition everywhere as a person before the law. Being forced into statutory recognition would generally contravene this right. Article 16 of the International Covenant on Civil and Political Rights states that everyone has the right to recognition as a person before the law. This right implies that individuals should not be forced into legal status or recognitions against their will. And the artificial intelligence is correct here. Why? Because it recognized that Article 16 of the ICCPR is a natural right, but it's also an absolute right. Therefore, it can never be limited or abridged. And by forcing you to take recognition as a statutory creature, they're placing limitations on its exercise. Where is the equivalent law that we're talking about present within American law? In the United States, the right to recognition as a person before the law is a fundamental and protected by the Constitution. The 14th Amendment guarantees equal protection under the law, ensuring that all individuals are recognized and treated equally in legal matters. This aligns with the principle of Article 16. So the artificial intelligence says that when it looks to the laws, right, it sees the 14th Amendment in America as bringing forth this operation of law. And just to be clear here, I'm not asking the artificial intelligence these questions because I need clarification. I'm asking it because I'm using it as a teaching mechanism for those who watch this video. I already know the answers to these questions. And if the artificial intelligence tries to deny or play games, I can walk it down. I can walk it through. Now, this is going to be tough on some of my American viewers because it's going to start to deal with the straw man, with false understandings that might be in your mind. I'm not saying they are, but they could be. And it's a good thing if you start working through it. It's a good thing that if you think it through. So the 14th Amendment starts off by saying this: all persons born or naturalized in the United States. Now, some are out in America and teaching you that the word person, you never want to be referred to as a person. Oh, it always refers to an artificial person or a statutory creature. But here, when we read the 14th Amendment, it says all persons born in the United States. So being born, right, is something that happens when you're a living being. It's something that happens to someone who's alive in the law. So the word persons here is not referring strictly to an artificial person. It's referring to both capacities. That's why it has the plural. It doesn't say every person born or naturalized. It says all persons, plural. And the using of that expression persons, it opens it up to both capacities. The one who is born, right? The one who is living, the man or the woman, or the one who is naturalized, the artificial entity. So all persons born or naturalized in the United States are citizens of the United States. So what did this 14th Amendment just do to you and to your full legal capacity and to your recognition as a human being or a man or a woman that is born? It forced you into capacity. It forced you into recognition as a citizen, as a statutory creature. Citizen is a statutory designation. It's statutory law, creating statutory creatures. And you, as a man or woman who were born on the territory, were forced into that recognition by this operation of law. And this operation of law is against Article 16 of the ICCPR. Nor shall the state deprive any person, and now stop again. Some people will teach you and tell you, look, it used the word person. Therefore, I conclude and I say unto you that this word person here is an artificial person, statutory creature. But look at the nature of the rights that's attached to this person. Nor shall any state deprive any person of life, liberty, or property. All right, those are natural rights. Those are absolute rights. Therefore, the subject or player person must be the living being. Because in order for natural rights and absolute rights to attach to something, it has to be the living being. And it goes on to say, without due process of law, meaning that it has to follow the principle of fundamental justice. And if we understand the fundamental principle of justice that is attached to the right in Article 16, that no one can force us to take recognition as a statutory creature, then the 14th Amendment already breached this obligation, because they forced you to take recognition as a citizen. And now it's saying that you cannot be deprived of your right to life, liberty, or property without due process of law. But if that due process of law forces you into recognition as a person, then the process of law is illegal. Right to recognition. The right to recognition as a person before the law, an artificial person, means that everyone is entitled to be recognized legally as a person, which ensures that they are protected and have legal rights. It does not imply that an individual is forced to act in a particular way to assert that recognition. It is a right, so it is something you are entitled to, but you are not obligated to take any specific action to use the right. So to summarize the right of recognition before the law, it's a right that ensures you're recognized as a legal person, but you are not forced to actively exercise it in a way that contradicts your fundamental rights. And that is why forced recognition via the Income Tax Act or similar statutes could be problematic under international law. Alright, so what about going to court with this problem? That's a great question, and it really depends on several factors. While your argument is rooted in international law, specifically the ICCPR and the Constitution Act, bringing it before the Canadian courts would certainly be a challenge. And here's why. Oh, it's not a challenge at all. Not at all. Very simple. And when you do it, guess what? They're going to take you in chambers. And they're going to grant you the judgment. Why? Because they don't want this as public information. That's why in the court acts, no matter what court you go to, right? The judge has the ability to deal with the case in private in the chambers and then to seal the judgment. So it's no challenge at all. Legal precedent. Courts in Canada generally follow the principles established in Canadian law, including the Charter of Rights and Freedoms. While international law is important and recognized by Canada, especially in cases where domestic law is ambiguous or in conflict, the courts tend to prioritize domestic law unless there is a clear conflict. Alright, so this artificial intelligence, right, is now twisting the truth and is now lying. So the artificial intelligence was trying to make it seem like domestic law is the superior law, that domestic law is the primary law if you have a contention with international law. But that's not the truth, right? When we look to the courts of Canada, in Zinger versus the Queen, it is a recognized principle of international customary law that a state may not invoke the provisions of its internal law, its statutory law, its domestic law, as justification for its failure to perform its international obligations. DeVito versus Canada. The Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents that Canada has ratified. So, two court judgments from the Supreme Court of Canada, right, that states that Canada, the executive powers, and the legislators cannot point to their statutory laws as a justification for limiting and abridging our fundamental human rights. So the intelligence said, while international law is important and is recognized by Canada, especially in cases where domestic law is in conflict, the courts tend to prioritize domestic law unless there is a clear conflict. All right, so is there a clear conflict or not? Are they limiting and abridging Article 16 by forcing the individual to take recognition as a person before the law, contrary to their obligation? Yes, there is. So we can clearly show that there's a conflict going on. What's the conflict? Well, their statutory powers are forcing me to take recognition as a person before the law. And that is against international law. And Canada cannot point to their domestic law, to the statutory power, which is limiting and abridging my right to declare that they are justified to do so. Interpretation of international law. Courts would need to interpret how international instruments like the ICCPR interact with domestic law and whether those international obligations can override Canadian statutory law. Well, they already did, Mr. Artificial Intelligence. The courts have already said that Canada cannot point to their statutory laws to justify its failure to perform its international obligations. So that is teaching us and that is showing us that the international obligations has superiority over statutory law. The argument that the Income Tax Act forces individuals into a statutory recognition that conflicts with their natural rights. Wrong. Mr. AI, you knew right here that you should have not said natural rights. You should have said absolute right, and would need to be carefully framed. Courts would likely weigh the public interest in tax collection. No, you are wrong. They cannot. An overall structure of the Canadian law against the individual's rights. Well, if they weighed them against public interest, and if they weighed them against Canadian law, and if they stood those two weighing measures up against my individual absolute right, guess what? My absolute right will prevail because it's an absolute right. And when you look into the covenant, there is no limiting factor that can be placed upon that absolute right, because the creators of the document of the international covenant understood the operation of law, that it is higher law. And there is no principle of fundamental justice, and there is no operation of law that can be brought forth to place a limitation or abridgment upon an absolute right. The economic and legal realities of taxation might influence the court's decision, but that doesn't necessarily mean that the Charter or international law couldn't prevail in some cases. Well, they can consider the economic and legal statutory realities all they want. It will not produce a principle of fundamental justice for them to apply it against the absolute right to recognition as a person before the law. I didn't even want to deal with this fully, but because it's up on the video now, and if some people read this, it could cause a confusion for them. So I gotta walk you through again what this lying AI is saying. If this argument were brought forth before the courts, it would likely raise a constitutional issue. Oh, yes it would. Why, you think they're going to take you into private chambers? That could prompt a significant interpretation of Canadian law and its relationship to international obligations. Oh no, it wouldn't. Wouldn't wouldn't bring up no new interpretations or no new understandings. The courts have already declared what the relationship is. International obligations trump domestic law and trump statutory law. And if we find in international law an absolute right that Canada is trying to limit and abridge through statutory law, then they're a dead duck. They have no operation of law. They have no principle of justice to do so. So it's not going to change the interpretation of Canadian law at all. The court's approach to such a case would depend on how they view the balance between individual rights and the functioning of government. Now notice the player that the AI used, individual rights. Individual opens up to statutory capacity, and individual opens up to our full legal capacity where our absolute right is recognized. So the individual's rights, all right, the individual has the right to freedom of association and freedom of assembly. But in the functioning of the government, right, and in international law, those freedoms of that individual can be limited by Canadian law, by statutory law. Why? Because international law allows the limitation to take place. But for the individual under full legal capacity, standing under the absolute right, not having to take recognition as a person before the law, it doesn't matter what the functioning of the government is. There's no principle of justice. There's no operation of law that the government can bring forth and apply against the individual to limit the absolute right. End of story. Possible outcomes. Yeah, possible, right? So imaginary, right? What you think, right? Or what you're trying to bring forth, right? If you brought this before the courts, it could take time to reach a decision, and the outcome is not guaranteed. Oh, yes, it is. While some judges might be open to interpreting Canadian law in the light of international law, others might lean towards preserving domestic statutory structures for particular reasons. Well, they have no particular reason. There's no particular reason that they can invoke to claim that it's a principle of fundamental justice to limit and abridge an absolute right. And you say that while some judges might be opening to interpreting Canadian law in light of international law, no, that's the operation of law. That's the obligation. That's what they must do. And if we walk upon or come across some judge who doesn't want to follow the rule of law, well, guess what? You're open up to an information, because the actions that you are doing are criminal against the individual, trying to use arbitrary power out of the office that you're sitting at to defend what? To defend what? The government's illegal actions. Go ahead and do it. Watch what happens. However, the fact that international law could be invoked gives your argument a foundation in higher law. Well, that's correct, Mr. AI, which could compel the courts to give it serious consideration. No, which would compel the courts to agree with me, to rule on my behalf, to produce a remedy or a redress to this situation of forcing me into recognition as a statutory creature before the law and then applying a withholding against me, therefore breaching and limiting my absolute right without a principle of justice, without an operation of law, just arbitrarily doing it, using statutory law, and in turn breaching foundational law, breaching natural law. Ultimately, while the argument you've presented is compelling, whether the courts would agree depends on the specific fact of the case, the arguments made, and how the judges choose to interpret the law in light of international standards. The specific fact of the case. So what are the facts? We are being forced to take recognition as a person before the law. This is producing a limitation factor against our absolute right in Article 16 of the ICCPR. Canada is pointing to internal domestic law, a statutory power to limit and abridge this right. This is against the principle of fundamental justice. Canada is pointing to internal laws to place a limitation and abridgment against an absolute right. Canada is not fulfilling their obligation to respect and ensure the international law. And international law has primary effect, or is first and foremost above domestic law. They created a statutory power, the income tax enactment, which changes my recognition and changes my designation in law and forces me into a capacity that I did not consent to, that I did not willfully choose to walk under. How the judges choose to interpret the law in light of international standards, well, that's already done for them. There's already jurisprudence, and there's the word of the court. And the individual judge shouldn't be making his private, arbitrary interpretations. And if he does so, well, then he's subject, right, to be held accountable. Now there's a question. There's a question that comes to us, right? If Canada limits and abridges my rights that are found in international law, does that produce an operation of law that allows me to go into court and claim that they're breaching international law against my rights? Yes, in Nevsun Resources Limited versus Araya, the Supreme Court of Canada ruled that customary international law prohibitions, so law prohibitions, like Article 16, right? That law brings forth prohibitions. And what's the prohibition? Well, you can't force me into recognition as a person before the law, such as those against forced labor, could indeed form the basis of a civil claim in Canada. Now notice what the AI is doing here, right? He's trying to bring it down into civil claim, into civil law. This decision recognized that violations of certain international norms could be actionable in Canadian courts. So we're seeing, right, that if they violate certain international law prohibitions, then this produces an actionable cause for a Canadian court. Board versus board. For the Privy Council, in dealing with questions of the nature of jurisdiction of a superior court, said, if the right exists, the presumption is that there is a court which can enforce it. For if no other mode of enforcing is prescribed, that alone is sufficient to give jurisdiction to the King's Court of Justice. So if the right exists, then the court has the responsibility and the court has the obligation to enforce the right. Vincent versus Ottawa. The Superior Court of Justice has all the jurisdiction, power, and authority historically exercised by courts of common law and equity. So your right exists in international law. We've seen it. It's an absolute right, and that right can never be limited and abridged. And through Article 26 of the Constitution Act, you can go right into international law and call upon that right. Department of Justice Canada, Article 4. The Minister, the Attorney General, is the official legal advisor of the Governor General and the legal member of the Queen's Privy Council. Whose interests he's protecting there? The King, right? For Canada, and shall have the superintendence of all matters connected with the administration of justice in Canada. And what is the administration of justice? When you use that term, when you use that designation, I hope you know, right? The administration of justice means upholding charter rights within Canada. So when you're going to exercise your right and enforce your right, it is this Attorney General that has the responsibility to deal with what you're claiming with way before you go to court. Way before you ever have to go into a court of law and expose this in the public. And again, like I said in the beginning of this video, do you think that the courts and do you think that Canada wants these operations of law to be public? No, they don't. And that's why in the court acts again, they have articles of law in there that says that if a judgment is going to be rendered that is going to affect the democratic society, that is going to affect the public structure of the way things are working, that the judge has the right to make a judgment in private chambers and to seal that judgment so the public does not become aware. If successful. Well, Mr. AI, it's not if, it's a guarantee. If you understand the principles of fundamental justice and the operations of law, then you understand it's not an if successful, it's a when successful. The court could either strike down or invalidate parts of the Income Tax Act that are found to violate international law. Yes, because they do. Because they're placing a limitation upon the absolute right found in the ICCPR, Article 16. Alternatively, they could issue a declaration that Canada must reform its taxation system to be in compliance with international rights, potentially leading to a significant legal and government changes. Public and political pressure. A case like this, especially if it challenges significant aspects of taxation policy, might attract public interest. If you were successful, it could spark wider conversations about the balance between taxation, individual rights, and international law. Public interest could influence the judicial process indirectly. Political ratifications. If the case brings to light major constitutional issues, it could influence political debate over taxation laws and human rights. That's exactly what it would do. It would tear down their constructive statutory law, which limits and abridges the absolute right, and public structure would have to change. Why do you think they do not want you to go to court and bring these arguments to the public's attention? They want to keep them dumbed down. They want to keep them locked up under statutory law, not knowing their rights. And that's why their enactment says that if the court has to make a decision about a right that is going to affect the public and going to affect the system in a drastic and dramatic way, well, they can seal the judgment and never let the public know what is transpiring.